So we have our expert with us, Surabhi is here, and the topic for this session, which we have today, is how to prepare for a future in insolvency and bankruptcy code. We have our expert with us, wherein she'll discuss the key aspects related to the topic. So mainly, she'll be discussing about overview and importance of insolvency laws, the recent trends and judgments, what are the job prospects, and some tips and tricks needed for this area of law. So Surabhi is currently working as a principal associate at Cyril Amarchal Mangadlas, and she has previously worked with esteemed organizations and firms. We are glad to have her today with us, and we are excited to host her. Over to you, Surabhi. Please go ahead.
Thank you, Nupriya, for an amazing introduction. First of all, thank you to everyone who has joined. I know it's a Sunday evening and it's been a short notice. So thank you for joining and taking out time for this. As Anupriya mentioned, we'll cover some aspects of, first we'll cover the basics of insolvency law and the practice and the procedure that is followed by NCLTs and NCLATs and how the entire mechanism is. I'll start with covering the background, and then I will take you through the entire process as to what all is required for filing, how a filing is done, everything. And I'm happy to take any questions that you may have. Anupriya, should we wait for a few minutes or should I begin the substantive portion now?
Yes, Surabhi, you can begin. So I'll keep admitting people.
Sure. All right. Okay. So as some of you may know, but I also believe that there are a lot of young students joining. So I'll just give a brief introduction of how insolvency law even came about in India. So before insolvency, there were several legislations that were essentially for recovery or winding up, etc. So under Companies Act, there were winding up provisions. There was recovery mechanism under the Recovery of Debt from Banks and Financial Institutions Act 1993. There was Surface Act for enforcement of security interest. So all of these laws were existing. However, still there were a lot of delays and there was no timely resolution of actually the distressed entity, which led to bringing about of the insolvency law. And through insolvency law, the regime changed from the recovery regime to a resolution regime. The idea and the objective of the insolvency law is to ensure that there is value maximization for all stakeholders involved. If Ashutosh, you could screen share the PPT, it may help everyone. Anupriya, if you can grant access rights or sharing rights to Ashutosh. So the objective of in IBC was to ensure time-bound value maximization of all assets of the corporate debtor in a time-bound manner. Also, at the same time, protecting and balancing the interest of various stakeholders involved. Now, before I go further into what is the process like, I'll just explain the basic terms so that it's easier to go further. Now, what is a corporate debtor? Corporate debtor is the entity which has defaulted in making some payment to a financial creditor or an operational creditor. I will come to what financial creditor and operational creditor also means. But before that, CIRP is essentially a state where a company has defaulted in payment of some liability that it has. So for example, I have a company called ABC Limited. I took a loan from SBI for 100 rupees at 12% interest. Now I was to pay in, say, 3 years, and I have defaulted in making the payment. Bank will first send me a recall notice. I still don't pay. Bank can then file a proceeding against me under Section 7, initiating corporate insolvency proceedings against my company. Now, CIRP can be initiated in 3 ways. It can be initiated either by a financial creditor, it can either be initiated by an operational creditor, or it can be initiated by the corporate debtor itself, which means the company that is defaulting itself can also initiate it. Now, what is a financial creditor? Financial creditor is anyone to whom a financial debt is owed. What is a financial debt? Financial debt means a debt uh, against the consideration of time value of money, which essentially means that if SBI has given a loan to my company, ABC Limited, at the rate of say 12%, there is the interest component, which is the time value of money. Now, this is a financial debt. A guarantee, a corporate guarantee is also a financial debt. Say my loan, say the loan to ABC Limited was secured by say XYZ Limited, which stood as a guarantor. Now, even this guarantee and the obligation under the guarantee would be covered as a financial debt. For a financial debt, a financial creditor can initiate proceedings against the corporate debtor under Section 7 of the Insolvency and Bankruptcy Code. Actually, before I even come to that, I'll just tell the basic thresholds. So earlier, when the Insolvency and Bankruptcy Code was enacted, the threshold was only 1 lakh rupees. However, the threshold was thereafter increased, and the threshold now is 1 crore. So for any debt above 1 crore, only can an insolvency be initiated. Secondly, because during 2020, when COVID had hit, it was also felt that there were certain businesses that could not perform because of the lockdown and COVID. Therefore, central government had also exempted a period of time in which if a company defaults, then insolvency proceedings cannot be done against that company for a default in that period. And that period is 25 March 2020 to 25 March 2021. So in this period, March 2020 to March 2021, if a company has defaulted, then no proceedings can be initiated against it. Now coming to Section 7, which is essentially how a financial creditor can file a petition or initiate insolvency proceedings against the corporate debtor. Now, under Section 7, a financial creditor can, so there is a form that is available. It's a tabular format in which details are mentioned with respect to the name of the corporate debtor, basic details of the company. But what is very important is to put the details of the loan or the facility agreement that is granted. You have to also attach and annex all of these documents along with the application. If there is an assignment of debt, then the assignment agreement also needs to be attached. The other main document that is required is the evidence of default. Now, how can you show default? For default, there could be documents, say an acknowledgement by the corporate debtor in an email or in some letter admitting to its liability, then that is an evidence of default. If there is a record with CIBIL or CRILIC, then those documents show evidence of that can constitute evidence of default. Now, other than this, there are also some other documents that need to be provided, which are for security, all the security that is held by the financial creditor, the records with ROC for creation of that security. Those documents also need to be provided along with it. So, and it is important that the application under Section 7 is complete in all respects, because if the application is not complete, then it is not going to be admitted by NCLT and NCLT, but however, it will not be directly rejected. NCLT will give an opportunity to provide the missing details. And if within the specified time period, documents are not provided, then NCLT has the right to reject the application. Now coming to Section 9. Section 9 includes debt owed to a operational creditor. Now, what is an operational creditor? Operational creditor is anyone who is providing, just allow me 1 second. Operational creditor is anyone who is providing any goods or services to the corporate debtor, and any amount that is owed towards those goods or services provided to the corporate debtor and which has not been paid will constitute operational debt. Now, the procedure for filing an application under Section 9 is different from the procedure for filing an application under Section 7. Under Section 9, there is a requirement under Section 8 to definitely send a demand notice to the corporate debtor, and corporate debtor then has 10 days to reply to the demand notice. Within 10 days, the corporate debtor has two options. Either they can pay the debt that is due, or they can show how the debt is disputed prior to the issuance of demand notice. So they will have to show existence of dispute or pay the debt. If either of the two situations is not done, then the operational creditor is free to approach NCLT in a format, again, that is prescribed for filing a Section 9 application. And along with the Section 9 application, the operational creditor can attach the demand notice, reply to the demand notice, whatever purchase orders that have been placed, all invoices, all the documents that are required and that concern that particular transaction will be annexed with the Section 9 application, and then it has to be filed before NCLT. Actually, one more aspect that I wanted to cover in financial creditors, because this became an issue right when insolvency proceedings had commenced in India in 2017. So home buyers earlier used to be categorized in the category of other creditors. However, there has been an amendment, and now home buyers are also classified as financial creditors. There is a requirement that home buyers can jointly file the application. However, when they file the application jointly, not less than 100 allottees under the same real estate project, or not less than 10% of the total number of such allottees under the same real estate project, whichever is lesser, can file the application. However, this should all the allottees or home buyers in this case should be part of the same real estate project. Then now coming to the third category, which is Section 10. So we have seen that an application can be initiated by a financial creditor under Section 7, then an operational creditor under Section 9. Then the third category is application by the corporate debtor itself. Now, in an application under Section 10, there are certain requirements that need to be fulfilled before an application is filed. Generally, this will be filed when the corporate debtor itself, due to bad market conditions, is suffering losses and is defaulting in repayment of its obligations to the banks or to the operational creditors. The onus to prove the debt and the financial situation of the corporate debtor will lie on the corporate applicant, which is approaching the NCLT. This will, of course, there cannot be any concealment or suppression of facts in this regard, and for that, adequate provisions have been made. The test for admitting a Section 10 application is the same as the Section 7 proceedings. Now, if the adjudicating authority comes to the conclusion that there is debt and default, then adjudicating authority will admit the Section 10 application. I will come to, because default jurisdiction and how default is to be interpreted has also evolved over time. So I will separately also come to that point. Now, a profit-making entity will not be sent under insolvency. There are clear judgments on that aspect. If there is a winding up petition pending against the corporate debtor, then the pendency is not a bar. Section 10 can still be admitted. However, if an order of liquidation or winding up has already been passed, then the Section 10 would be rejected. Now coming to the interesting topic of default. So default under the Insolvency and Bankruptcy Code has evolved over time and has, after change, also come back to where it started from. So the first important judgment in insolvency laws was the innovative judgment. Here, what the Supreme Court held was that the only thing that NCLT has to look at is debt and default. The same principle was also held in Bharat High Tech, where Supreme Court clearly held that NCLT is to look at whether there is debt or default, and there are only two outcomes possible. Either if there is debt and default that is established, then you can admit or you can reject the application under section 7, 9 or 10 as the case may be. Now, for an application to be admitted, first important criteria is that there should be debt, and second, that there should be default of that debt by that corporate debtor. However, in Vidarbha, Supreme Court changed this principle, and here what had happened was that Supreme Court held that even if there is debt and default, NCLT has the jurisdiction to consider whether or not to admit the insolvency petition against the corporate debtor. This judgment has been used by several corporate debtors till the time the review order came and subsequent orders came, and it still gets used a lot. Now, when such an objection is raised by the corporate debtor, the response to that is that in review petition, there was a review petition filed in the same Vidarbha judgment. In that, Supreme Court held that the findings that are given in Vidarbha are for the facts and circumstances of that case only, and they are not to be adopted as principles in other cases. They again went back and relied upon Bharat High-Tech judgment of Supreme Court and said debt and default needs to be established. In fact, thereafter in another case, in Suresh Kumar Reddy, Supreme Court once again said that the findings in Vidarbha case are meant for that case only, and only thing that NCLT has to see in a Section 7 application is whether there is debt and whether there is default. Now, one more issue I want to cover before we jump to the next issue is that at times what happens is that you have filed the Section 7 petition, and now there could be further documents that you may need to file. An objection may be raised by the other side that these were not part of the Section 7 petition and therefore cannot be relied upon. However, there are judgments from NCLAT and Supreme Court which say essentially Dena Bank, Supreme Court in Dena Bank judgment said that Section 7 is a tabular format, and therefore if additional documents are needed to be relied upon, they can be filed subsequently by the financial creditor. Even NCLAT has held that through a supplementary affidavit or a rejoinder, you can bring on record additional documents if need be. Now, coming to the next issue. So the time period is provided in Section 7 and Section 9 also, and 10 also, for 14 days. However, Supreme Court has held this period to be directory and not mandatory. This is the time period in which adjudicating authority has to decide the Section 7, 9 or 10 application as it may be, but this timeline has been said to be only directory and not mandatory. So now we have just laid down the process. We will of course come to each heading of this, but just laying down the process. So what happens is once a Section 7, 9 or 10 application is filed, and if debt and default are established, and in case of a Section 9, the court will also see that whether there is a pre-existing dispute or not. Only if there is no pre-existing dispute, then a Section 9 will be admitted. After the Section 7, 9 or 10 petition is admitted, corporate insolvency resolution process starts. Now, what that would entail is that an IRP will be appointed. IRP is interim resolution professional. We'll cover what are the duties of IRP also subsequently. A moratorium will be imposed. Moratorium also we'll cover in detail in subsequent slides. What moratorium essentially does is that it will put a stay on all proceedings that are going on against the corporate debtor. It will put a stay on institution of any new proceedings against the corporate debtor. It will also put a stay on any transfer, alienation of any of the security held by the corporate debtor. The purpose of moratorium is essentially to ensure that there are no conflicting judgments or conflicting orders or conflicting remedies being exercised when the corporate debtor is being sought to be resolved. And in order to ensure that there is an orderly resolution and creditors are not individually enforcing their remedies during the time when the CIRP is being conducted. After the interim resolution professional takes over the corporate debtor, Then subsequently, moratorium is declared and public announcement will be made by the interim resolution professional calling for all claims that financial or operational creditors or any other creditors may have against the said corporate debtor. Then it will collate all the claims. It will first verify if the claims are valid. Then it will collate all the claims. It will constitute a committee of creditors. A committee of creditors is formed of the financial creditors of the corporate debtor, which will include, say, the banks and financial institutions, etc. Then it will call for resolution plans from prospective resolution applicants. Resolution plan also we'll cover in detail subsequently. After it has received resolution plans, it will evaluate if they meet the criteria provided under the insolvency code and are not in violation of any laws. Then it will present the same before the COC. COC, if it considers in its commercial wisdom that the plans are feasible and viable, then it will approve. And if COC approves the resolution plan, then it is further sent to NCLT for its approval, in which case, if NCLT also approves, then the plan will be implemented and this new successful bidder, which has given its bid for the corporate debtor, will take over the company. If, however, COC comes to the conclusion that no feasible or viable plans have come forward and there is no suitable resolution plan, therefore they will vote for liquidation of the corporate debtor, and in that case, the corporate debtor will then proceed towards liquidation. Now, the one important issue that came was the simultaneous proceedings against the principal borrower and corporate guarantor or personal guarantors. Now, a lot of times corporate debtors or corporate guarantors, as the case may be, took the defense that if the proceeding is pending against the principal borrower, then a simultaneous proceedings cannot be initiated against the corporate guarantor. In this case, the first important judgment that we should note is State Bank of India versus Ramakrishna and another. Here, Supreme Court noted that Section 14, which provides for moratorium, has been amended, and it does not, and it says that there is no moratorium available to against a guarantor, and therefore the liability of principal borrower and corporate guarantor, as per the Indian Contract Act, is coextensive. However, in spite of this judgment, there was a judgment of NCLAT, National Company Law Appellate Tribunal, in Piramal Enterprises, where NCLAT held that simultaneous proceedings against the principal borrower and a corporate guarantor cannot be initiated, or simultaneous proceedings against co-guarantors also cannot be initiated. That judgment of NCLAT is currently pending in appeal before Supreme Court. However, while during the pendency of the appeal before Supreme Court, another judgment came from NCLAT, same bench strength, in State Bank of India versus Athena. Here, NCLAT held that simultaneous proceedings against a principal borrower and a corporate guarantor can be initiated, and the liability of principal borrower and corporate guarantor is coextensive. Interestingly, sometime later, on the issue of personal guarantors, while of course the principle can equally be applied to a corporate guarantor as well, Supreme Court in Lalit Kumar Jain held that approval of a resolution plan relating to a corporate guarantor does not discharge the liabilities of personal guarantors to corporate debtors, thereby again upholding the coextensive liability of the principal borrower and the guarantor. Yes, the other issue that has come up at times before in Section 7 proceedings is the applicability of Limitation Act. And in fact, the provisions of Insolvency and Bankruptcy Code were also amended, and Section 235A was included in IBC, which holds that Limitation Act will be applicable in case of insolvency proceedings. And Section 18 of Limitation Act, which provides that the period of limitation will get extended if there is an acknowledgement during the period before which the limitation period expires, will extend the limitation period, is also applicable in case of insolvency proceedings. It was also held in the case of BK Educational Services versus Parag Gupta, that the period of limitation for insolvency proceedings would be 3 years as per Article 137 of the Limitation Act. Another point to be noted here is that Supreme Court has clarified in Lakshmipat Surana and thereafter NCLAT in Topworth that the period of limitation for Section 7 and this period of 3 years is to be calculated from the date of default, and it is not to be calculated from the date when the account was declared as NPA, which means non-performing asset. Yes. Now, admission order. Admission order is passed if the debt and default are established, then an admission order would be passed, thereby sending the corporate debtor into insolvency. Now, consequences of an admission order being passed would be: first, an interim resolution professional will be appointed. Second, moratorium will be declared. Third, interim resolution professional will call for claims from financial creditors, operational creditors, and other creditors. There is also a limit on the number of assignments that an interim resolution professional can take. This has been recently introduced. A resolution professional can only take 10 assignments, out of which not more than 3 can be exceeding 1,000 crores. Now, coming to the next important issue of moratorium. So, moratorium essentially means that this is the period where there will be no initiation of further proceedings, or the existing proceedings will come to a halt, and there will be no security enforcement during this period. It starts from the date when the NCLT admits the Section 7, 9, or 10 petition, and it concludes till the time that plan is approved. If, however, the corporate debtor is sent into liquidation, then in that case, Section 14 moratorium will end. However, as per Section 33, subclause 5 of the Insolvency and Bankruptcy Code, moratorium under liquidation process will begin. The purpose of the moratorium, as I was explaining earlier, is to keep the assets of the corporate debtor together. Otherwise, individual creditors may enforce their rights, and that may cause difficulty in the effective resolution of the corporate debtor in its entirety. In this, what is important to note is that there are certain services that are not that cannot be terminated even during the process of a moratorium. So, for example, essential services, the supply of essential goods or services is not terminated during the period of moratorium, because that is important for keeping the corporate debtor as a going concern. Now, the other important point is that while any initiation of new proceedings or existing proceedings is stayed, any beneficial proceedings that may be in the interest of the corporate debtor itself are not stayed. They continue to proceed. Yes, there were also certain judgments on whether guarantees or bank guarantees or performance bank guarantees are covered during the period of moratorium. However, it has been clarified by NCLATs that performance bank guarantees and bank guarantees are not covered during the period of moratorium. Moratorium will also not include initiation of CIRP proceedings against a subsidiary company. A subsidiary company is a separate, distinct legal entity, and any moratorium against the parent company will not automatically apply to a subsidiary company. Now, one more important fact one more important consideration that came up before courts was with respect to termination of important contracts during the period of moratorium. Now, Supreme Court in Gujarat Urja Vikas versus Amit Gupta held that the following contracts cannot be terminated during the period of moratorium. First, the contract that is central to the success of the CIRP. Otherwise, it would defeat the very purpose of the CIRP if such contracts are allowed to be terminated. The termination of the contract is solely on the ground of insolvency of the corporate debtor. And thirdly, the corporate debtor would not be able to maintain itself as a going concern on its termination. These three categories of contracts are not allowed to be terminated during the course of moratorium. However, in further judgment of Tata Consultancy, Supreme Court also clarified that the NCLT does not have residuary jurisdiction with respect to termination of contracts if there is no nexus between the contract being terminated and the insolvency. It is only in the specified circumstances can NCLT interfere and stop the termination of contract, which are the three circumstances that I just told you about. Moratorium is also not applicable in case of negotiable instruments, in case of proceedings under 138 of Negotiable Instruments Act. Now, but however, there is an important distinction to be made here. So 138 of Negotiable Instruments Act, if I'll just clarify that also, is these are the proceedings that are initiated in case of dishonor of checks. Now, against the company, the moratorium will come into play and 138 proceedings against the company will be stayed. However, if there is a promoter or a whole-time director of the corporate debtor against which any such proceedings are pending, then those proceedings against the promoter or the director will continue to operate and will not be stayed by virtue of moratorium under Section 14. Now coming to the role of IRPs and RPs. Now IRP is an interim resolution professional and RP stands for resolution professional. Now when Section 7, 9 or 10 is admitted, then an interim resolution professional is appointed by the NCLT. Two things to be kept in mind whenever you are drafting an application under any of these provisions. Details of the proposed interim resolution professional that you wish to propose need to be added. There are also certain documents and written confirmations from that interim resolution professional that need to be obtained. The formats are already prescribed under the code and the regulations. They are essentially to the effect that the person is not a related party to this company and it has the valid registrations, etc. So those written confirmations from the proposed IRP need to be filed along with those applications. Secondly, NCLT will also check if there are any disciplinary proceedings pending against such an individual. If there are any such proceedings pending against the individual, such IRP, NCLT will not appoint such a person as the insolvency resolution professional, interim resolution professional of the corporate debtor. The other thing to be kept in mind is that the IRP, once it is appointed, will take over the charge of the corporate debtor. Its job would include public announcement for calling for claims from various creditors, collation of all those claims. Then subsequently, COC will have a right to appoint. So once IRP is appointed, it will collate all claims. It will then constitute something called a committee of creditors. Committee of creditors are secured financial creditors or may include unsecured financial creditors also, but essentially financial creditors of the corporate debtor, which will include banks and financial institutions. Once COC is constituted, COC has the right to either confirm the same person as the resolution professional or appoint someone else that they may deem appropriate as the resolution professional. Now, once the resolution professional is appointed, it also has several duties under the code, which are detailed under Section 18 and 25 of the IBC, which broadly include that an information memorandum will be prepared. Information memorandum will include all the assets and liabilities and details of the corporate debtor. It will also call for resolution plans. Once resolution plans are received, then the resolution professional will accordingly prepare a list of those resolution applicants. And if the resolution plans are compliant with the provisions of the code, they'll be placed before the committee of creditors. Once they are placed before the committee of creditors will review them from the feasibility and viability perspective. And if COC comes to the conclusion by a majority of 66% that the plan is feasible and viable, it will vote in favor of such a plan. And once it is approved by COC, it will be placed before NCLT for its approval. Now, another important stage that needs to be considered, and on this courts have been quite liberal, is Section 12A of the Insolvency and Bankruptcy Code. Section 12A essentially provides that the CIRP, even after admission under Section 7, 9, or 10, can be withdrawn if 90% of the COC is satisfied. This can also happen at the stage of liquidation. Even after liquidation order is passed, if there is a proposal before COC, which COC approves with 90% majority, then the proceedings can be withdrawn as per Section 12A of the Insolvency and Bankruptcy Code. Now coming to the resolution plan. Now, resolution plan is essentially a document that is provided by a prospective resolution applicant. Resolution applicant is essentially the person who will come forward. In very simple terms, will be the person who will come forward and say, okay, this is my terms of payment for this category of creditors, and this is how I intend to take over the company. Now, there are certain mandatory contents of a resolution plan that we'll come to in a minute. But broadly, the resolution plan is required to be compliant as per Section 30, subclause 2 of the Insolvency and Bankruptcy Code. In fact, Supreme Court has even held in Maharashtra seamless that resolution plan can be below the liquidation value of the corporate debtor. There is also, as per Section 30, there is of the Insolvency and Bankruptcy Code, and Supreme Court has interpreted this section in JP judgment, where they have specified the treatment to be given to dissenting financial creditors. Dissenting financial creditors are required to be paid a minimum of liquidation value as per Section 30 of Insolvency and Bankruptcy Code. Further, Supreme Court in JP also said that dissenting financial creditors are to be paid in cash and in priority before any other assenting financial creditors. Now, there are some mandatory contents of the resolution plan. The resolution plan, and these are all prescribed under the CIRP regulations, which are framed under the Insolvency and Bankruptcy Code. The resolution plan has to provide for payment of CIRP costs. Resolution plan has to provide for certain measures necessary to maximize the value of assets, priority to amount due to operational creditors over financial creditors, management of affairs of the corporate debtor after approval of the resolution plan, and implementation and supervision of the resolution plan. Resolution plan to indicate how interest of all stakeholders are being considered, and that resolution plan is not in contravention of any of the applicable laws. Sufficient details in resolution plan to enable the committee to assess the feasibility and viability. Then another important point to be considered is, and this is something that has been a subject matter of different judicial interpretations, is the commercial wisdom of COC. Now, how a plan will be evaluated is in the commercial wisdom of COC. Of course, there are requirements that the plan has to meet. Like we saw that there are certain mandatory contents that the resolution plan needs to have. It needs to be compliant with the applicable laws. However, to determine whether the plan is feasible or viable is within the commercial wisdom and domain of the committee of creditors. In fact, the first important judgment on this is K. Shashidhar, which is on your screen right now. Supreme Court strongly upheld the commercial wisdom of COC and also said that judicial interpretation of commercial wisdom cannot be, judicial review of commercial wisdom of COC is not possible. The same principle has been upheld in multitude of judgments in SR, in Maharashtra, Seamless, in various judgments. In fact, if a resolution plan is approved by the COC and it is presented before NCLT and NCLT feels that there are certain modifications that are required to be made in the plan, then NCLT cannot directly make those modifications. NCLT is required to send the plan back to the COC, and COC can then examine and make the modifications, and then the modified plan will first be approved by COC and then be placed before NCLT for its approval. A classic case of this is also Videocon. In Videocon, a plan was approved by NCLT, initially by COC and then by NCLT. When the matter went before NCLT, COC decided to, in light of certain observations that were made in the plan approval order by NCLT, essentially on the nature of that the payment to operational creditors, etc., may be reconsidered. And on similar grounds, NCLT also stayed the plan approval order of NCLT. Looking at the observations of NCLT and NCLAT, COC had filed an affidavit before National Company Law Appellate Tribunal stating that it would, that the plan be remanded back to COC for COC to reconsider. And NCLAT, after detailed hearings, in fact, even remanded the matter back to the COC for its consideration. The matter is currently pending. The NCLAT's judgment went into appeal in Supreme Court, and the matter is currently pending before Supreme Court. So Supreme Court has not yet taken a decision on this issue, but commercial wisdom has been considered to be paramount by all courts, Supreme Court and NCLT and NCLAT. Then coming to the next issue of withdrawal of resolution plan. This is also an interesting issue, and there were several judgments on it. Ultimately, EBIC's judgment of Supreme Court settled this issue, where Supreme Court held that a resolution plan, once approved by the COC, cannot be withdrawn by the resolution applicant. There are several cases in which resolution applicants, after the approval of COC, create issues in implementation of the plan or attempt to withdraw from the plan. So this judgment settled that position, that resolution applicant is not allowed to withdraw from the resolution plan once it is approved by the COC. There are also some judgments which there are also situations, and this is under consideration of various forums at the moment, in cases where resolution applicants have taken over the corporate debtor, kept it for a few months, and then handed it over back to the COC. And a second CIRP had to be conducted to find another resolution applicant, and then the corporate debtor was resolved. In that case, COC has filed an application seeking losses from the erstwhile successful resolution applicant, and while NCLT Mumbai has recently declined that relief to the COC, the matter is currently pending before NCLT. Now, another important issue is whether time-bound, the conundrum between time-bound resolution versus value maximization. So, as per Section 12 of Insolvency and Bankruptcy Code, CIRP is to be concluded within 180 days, which can be extended by further 90 days, and ultimately within 330 days, including the litigation period, CIRP ought to be concluded. However, Supreme Court in SR judgment held that 330-day timeline is not mandatory, and if the situation so requires, as resolution is more important than liquidation, the timeline beyond 330 days can also be extended. And there are several cases, especially the larger accounts, where CIRP for some or the other reason could not be concluded within the period of 330 days, and timelines and NCLT have been generous and liberal in allowing extension of timelines in such cases, even beyond 330 days. However, another issue that has come up in this light is with respect to interpretation of Regulation 39(1)(a). Now, Regulation 39(1)(a), I'll just read out for everyone's easy reference, is the resolution professional may, if envisaged in the request for resolution plan, A, allow modification of the resolution plan received under subregulation 1, but not more than once, or B, use a challenge mechanism to enable resolution applicants to improve their plans. Now, this particular regulation has been subject of debate in several of the cases that have recently come before NCLT and NCLAT. The situation that the way NCLTs have interpreted this provision is again by emphasizing on primacy of the commercial wisdom of COC. NCLT in Torrent case, in Vista ITCL versus Torrent case, held that if the terms of the RFRP provide, then COC has the discretion to call for revised resolution plans and or conduct a challenge mechanism. A lot of these, in fact, all the 4 cases cited here, the argument that was taken here was that because COC had excised one of the other options, either revise the resolution plan or sort a challenge mechanism, it could not do the other option because of the words or used in 39(1)(a), where it says that resolution professional may, if envisaged in RFRP, allow modification, but not more than once, or use a challenge mechanism. The interpretation of the word or came into question in Consortium of Prudent versus Ravi Shankar Devarakonda. Also, here also what NCLT and NCLAT both upheld was the word or is to be not held as that COC is bound by only one of the options, and COC has the option, especially if it is provided in the RFRP, to excise both the options. NCLT Chennai in M.K. Rajgopalan had also taken a view that any bar that is placed, if at all it is placed under 39(1)(a), is only on the resolution professional and not on the COC because of the wording of 39(1)(a), because it starts with saying resolution professional may. And therefore, NCLT Chennai was of the view that if there is a bar, it is only on the RP and not the COC. The NCLT Chennai judgment is currently pending an appeal before NCLT Chennai. Jindal Stainless, here there was a challenge process conducted, and thereafter one of the resolution applicants had submitted a revised resolution plan. However, COC decided not to consider the revised resolution plan, and NCLAT upheld the commercial wisdom of COC and said that if COC has decided not to consider the revised resolution plan, then it is within the domain and commercial wisdom of COC, and upheld that decision. Another issue that has come up in several CIRPs. Another issue that has come up in several CIRPs but is now settled by Supreme Court is the issue of pledge enforcement. Now, the argument that corporate debtors used to raise was that if there is a pledge that is provided and the pledge has been invoked by the lender, and in case of demat shares, what happens is, before getting in the judgment, I will give you a brief background so that the issue is clear, that when there are demat shares, after a pledge is invoked, in order for the lender to proceed with sale of those shares, it will first have to take possession of those shares. And in case of demat shares, the way to take possession would be that in the depository records, the beneficial owner of those shares would be changed. Now, when the beneficial owner is changed, the corporate debtors used to argue that sale is equivalent to change of beneficial owner, in spite of the fact that the lenders may not have actually sold the shares or recovered any money thereof. But because the term used in the depository records is beneficial owner, as per the Depositories Act and Depositories Regulations, that was the argument that corporate debtors used to raise. So the matter was, there are several High Court judgments that conflict on this. However, Supreme Court in PTC judgment has settled the position, and Supreme Court has said that only change in name of the records of the depository and the change of beneficial owner would not amount to recovery of any money from the lender by the lender, and therefore the change in ownership in the depository account is not equivalent to discharge of debt or sale of shares in the sale of shares by the lender. Then coming to the issue of personal guarantee, this we'll cover only in brief because I believe I'm already reaching my timeline. So the provisions with respect to corporate insolvency of corporate debtors and guarantors were enforced in 2016 only. However, for personal guarantors, they were enforced in 2019. In Lalit Kumar Jain, Supreme Court clearly held that the resolution plan having been approved for a principal borrower would not mean that the proceedings cannot be initiated against the personal guarantor. The procedure for proceedings against a personal guarantor is different from the procedure in case of corporate debtors. However, the issues with respect to constitutionality of several of these provisions is pending before Supreme Court right now, and Supreme Court is adjudicating these issues. That is all from my end. If there are any questions, I'm happy to answer.
All right. Surabhi, thank you so much for such an insightful and such a wonderful session. So moving on towards the question and answers, and if there are any doubts, if participants have any doubt, you can either raise your hand, so I'll unmute you, or you can type your query in the chat box. I'll read it out for you.
Only one more. Is it possible to upload any level or anything on any?
Yes, you're audible.
No, is it possible to upload the recorded session, madam, with PPT?
For the PPT, yes, you'll get the PPT. It will be uploaded in the LMS portal.
So thank you for this nice class. Thank you.
Yeah.
It's very, very useful class. Thank you.
Yeah. All right. So one participant has asked, Surabhi, please guide us on how to get started in this sector as a fresher.
Okay. So thank you for that question. I believe that may be useful for several of you. So see now, if you, I believe this is a law student that is asking this question. So now if I would suggest that first read up on insolvency and bankruptcy code, and the code is actually it is a simple code. Like even if you just read the procedure that is laid down in the code, you will get an understanding of in what sequence and how the entire process works. There are several firms that specialize, and there are several senior advocates that specialize in this area. If you think that you want to focus only on insolvency laws, I suggest that you may join their chambers or those firms that specialize only in this. I would also suggest that you should get yourself familiar with NCLTs and NCLATs so that you have a better understanding, because I have right now told you a theoretical way of how things are done, but there is also, as is true for all litigation lawyers, there are also practical things that need to be kept in mind. So I suggest that if you want to focus on this, first, I would suggest that read the Insolvency and Bankruptcy Code and the CIRP regulations particularly, and familiarize yourself with these laws. And there are several important judgments that keep coming on this issue, and there are several platforms like say IBC laws, etc., which are devoted only to the insolvency law practice, and they keep uploading judgments with respect to insolvency laws. So you may subscribe to that. and you may join any specialized firm or a senior advocate and go on from there. If there is still any question, I'm happy to answer.
All right, thank you for your answer, Surabhi. Moving on to the next question. All right, so the subsequent question to this is it not possible to practice independently?
Yes, of course. Yes, of course. You can practice independently. In fact, NCLTs, a lot of NCLTs are not particularly asking that, only a senior advocate. I mean, no court particularly asks, but here a lot of junior counsels appear in NCLTs and NCLTs on a regular basis. So, of course, you can appear independently and practice.
Right. Thank you, Surabhi. Now we are moving on towards another question. So Himanshi, I have unmuted you. Please go ahead.
Good evening, ma'am. Ma'am, first of all, your session was really amazing and informative. So I have a question for you, ma'am, that I'm an aspiring M&A lawyer. So how much knowledge of the insolvency and bankruptcy code should I possess? Is it should be only basic, or should I delve into the detailed concepts?
So, Himanshi, since you're in M&A practice, I would suggest even a basic understanding of the procedures should be good enough for you, because there are a lot of nitty-gritties in the process that, if you have a specific case, then anyways, you will get into it. But a basic understanding is good enough for you then.
Okay, ma'am. Thank you.
All right, we have another question from Mr. Ramakrishna. Give me a minute. I'll just unmute. Yes, Mr. Ramakrishna, please go ahead.
Hello, ma'am. Good evening. I have a doubt regarding the debt in which you said that insolvency proceeding can be initiated. If the debt is 1 crore, individual debt or individual finances debt, or what somebody's there are three types now: corporate debtor or operational creditor. Means individual's debt should be at least 1 crore, or total debt should be at least 1 crore, or overdue should be 1 crore.
Now, if it is operational creditor also, then also it should be the debt of 1 crore is the threshold that has been set. It used to be 1 lakh, but it has been increased to 1 crore.
Okay. Thank you, ma'am.
All right, moving ahead to next question. Pankaj, you have been unmuted. Please go ahead.
Ma'am, are there any specialized professionals who assist in making of resolution plans?
Yes, there are. So generally what happens is that there are these big four that you may have heard of: EY, Deloitte, etc., KPMG. These are some of the major firms that are involved in almost all insolvency cases. Either they will be acting along with the resolution professional, helping the resolution professional, and there are also process advisor firms. These also firms and several other firms also help in the process of etc. In fact, even the resolution applicant will have its own counsels. Resolution applicants' counsels will also help in drafting and preparing of the resolution plans. So generally process advisors and legal advisors assist in the process, and of course commercials come from the resolution applicant itself.
So if one wants to assist someone in making of resolution plan, so one has to take a separate degree?
No, I mean, you don't need a degree unless you want to practice law. Then of course you need LLB. But if you want to be a process advisor, there is no degree that is required particularly.
Or any specialized course for making of resolution plans?
So there is no mandatory requirement that is there. However, if you want to be employed by any of these organizations, then they may have their own individual criteria. And therefore, what may be helpful. So if you want to do the legal advisory, then of course you need to have the LLB degree, like I said. But if you want to be a process advisor, then in that case, it is always beneficial that you know the laws and the processes and what are the latest developments in the field. But there is no mandatory requirement that I'm aware of that, you need to have if you just want to assist in that process.
Okay, ma'am. Thank you. Thanks, ma'am.
All right. Thank you, Pankaj, for your doubt. We have one question. Invoking something about invoking pledge on share. Yeah. All right. So you can raise your hand, Mr. Ramanan. So I'll unmute you. Till the time, Ayan, you have been unmuted. Please go ahead.
Hello.
Hi.
Yeah, hi. So when does IRP becomes RP?
So after a section, after insolvency commences, that is after NCLT passes an admission order, at that stage, an interim resolution professional is appointed. Now, interim resolution professional will then call for claims and constitute a committee of creditors. The committee of creditors can either approve the same interim resolution professional as a resolution professional if they so desire, or if they, for whatever reasons that they may think appropriate, if they think that no, I don't want to continue with this IRP, I want to appoint someone else, then they will have to pass a resolution to that effect by 66% majority. And then appropriate application has to be filed before NCLT for both situations. Even if you want to continue the same IRP as RP, you have to file an application for NCLT. And even if you want to change, you will have to give reasons and you will have to file an application before NCLT, show the COC resolution, and then NCLT will then appoint the person as resolution professional.
So RP is when you go into the litigation in the NCLT. The adjudicating authority has approved the plan. Is that correct?
No, not approve the plan. So in case, so when I'll give an example to make it simpler. Say SBI has filed a Section 7 petition against ABC Limited. Now, in the Section 7 petition, you have to, along with disclosing the details of debt and default, you also have to disclose details of proposed interim resolution professional. SBI will disclose all of these details. NCLT will see, okay, fine, ABC Limited has committed debt and default. And then if it is satisfied that there is debt and default, it will admit Section 7. When it is admitting Section 7, what it essentially means is that a CIRP process will start from here. So at the start stage, they will only appoint an interim resolution professional. After the interim resolution professional is appointed, he or she will take over the corporate debtor and manage its affairs and do all the duties that are required under Section 18 and 25, Section 18 actually, for IRP of the code. After COC is constituted, and the way COC will be constituted is that after as a resolution professional, I look at all claims and say, okay, fine, these are the financial creditors. Accordingly, a committee of creditors is constituted. Once a committee of creditors is constituted, then committee of creditors may say, okay, fine, this person, whoever is the IRP, I'm happy with it. Let's continue with the same person as RP. So then they will pass a resolution to that effect. They will, the NCLT will then confirm that person as the RP. But the plan approval process will start after that. After IRP to RP appointment is done, RP will then call for expression of interest from prospective resolution applicants. Resolution applicant, whoever is interested in that company, will come forward, submit whatever plan that they wish to provide for that company. Then after that, COC will evaluate the plans. If COC is happy, they will approve the plan. So plan approval process comes later. IRP to RP appointment happens much before.
Okay, thank you.
All right. Thank you for your question, Ayan. Moving on towards some of the last couple of questions. So I'll be taking 2 more questions because we are running out of time apparently. Okay, so one person is asking, can you please share in? Okay, that I'll do that. That question is for me. Okay, all right. I believe this brings us to the end of the session. I see no more questions. If there are any questions, you can quickly raise your hand or you can type down in the chat box in another minute. Otherwise, we'll end this session. Also, I've shared the feedback form. I request all the participants to please fill the feedback form. So, Surabhi, I believe. Yes.
If there are any questions and you want to reach out to me separately, please feel free to reach out to me, and whatever is possible and whatever I can help you with, I will help you with.
All right. So yes, we have already shared the Surabhi's LinkedIn profile with all of you while we were sharing the notifications. So I believe you can reach out to her on LinkedIn later this lecture. Thank you so much, Surabhi, again for being an amazing expert, and we hope to invite you for future sessions as well. Thank you, and thank you everyone for attending it on a Sunday evening.
Thank you everyone, first of all, for joining at such short notice, that too on a Sunday. I'm very sorry if I bored you with any of this. I hope it was fruitful for you, and thank you, Anupriya, for giving me the opportunity. It would be my pleasure to come back again.
Thank you so much, Surabhi. Bye-bye.
Thank you so
Good
much.
night.
Thank you.